Well, hello everyone again. It's Brandon Sterling, and I'm with Clint Richardson, and we wanted to get into uh, where we left off on KL in particular. We made a video on KL called "Is KL for Real?" We went over several problem areas that we highlighted over a year ago now. Now, I made a part two video to that too. I found some more discrepancies, let's just say. Basically, everything he talks about, trusts
Everything.
and taxes, pretty much the opposite is true once you look into it. So, a recent discovery just into our hands. Nonetheless, actually, from an argument between two gurus, KL and Alphonse, that the truth came to light. It turns out that we found out KL's real name. His name is Peter Wentland, and by finding this out, we were able to search his name. Turns out he has some court cases on the record. So we're going to highlight what went down in that, and we'll talk about trust a little bit more, I'm sure. So
And just to add to the insult here, we are using public records. We are not exposing anything that's private. These are public court documents. And it's funny because in the court document itself, apparently he tried to suppress the record of it going public. It says that in the actual case, which I thought was pretty funny. But let's just say that there's a good reason that this guy goes by KL instead of his actual, if you will, legal name that he does business in or commerce in, the straw man name, right? We can kind of get a clue now why he uses and why all of these guys seldom use their real name. There's nothing wrong with using a different name unless your intention is to be dishonest and to harm people. And let me just say one other thing before I get started, because I'm starting to think this might very well be an organized thing that's made
yeah,
to look kind of disorganized. Because the information that I present in my work straight from the legal sources, which in fact is quite opposite a lot of the times to what these guys are presenting. But what ends up happening is cases like this and things that these guys are promoting and saying end up harming the appearance of legitimacy in the work that I do, the actual research that I do, whereas these guys are learning from each other, passing on the baton. I can only assume it's some one of the three-letter agencies, I don't know, that are constantly incorrectly and illegitimately approaching the court so that no one ever really could, or in other words, to set sort of a precedent in case by case record where these judges don't even have to look at your case anymore. They just automatically say, okay, this is a sovereign citizen, or this is this, or this is this, this is the tax protest movement, and therefore we're going to dismiss the case. It's almost as if this is an organized group of people that support one another that are really clouding any legitimacy of any real research out there. And that's kind of how I'm feeling lately. It's just too weird and too
Hmm.
it's almost too opposite of reality
yeah,
to even consider being, like, there is no way that people could have come up with this on their own.
yeah.
It's a mythology that I can't even comprehend. Now, back in the day, 2010 time, I remember hearing this and understand mixing these two things up, the legitimacy of a person, a status, a straw man, with the redemption slash, cracking the code and tax protests and all that stuff. And when you mix those two, this is what you get. Whereas I'm just looking at, hey, these are the legal definitions of things. This is the theory or the science behind the law. Over here, we have a complete mythology not built on the science. And I really don't understand. The only thing I can think of really now at this point is that this is a controlled opposition meant to look uncontrolled, just just random people popping up and promoting things. But and then the other thing is, I know you get the same thing, and I think we both agree here. Quit sending websites that are the same exact damn thing and asking them if they're legitimate. There is nothing legitimate about any website out there. I don't care if it's the Assembly of God, the Assembly of Satan, the Assembly of this, whatever it is, state national, state citizen, redemption, all of that is recognized in this case we're about to show you. It's all illegitimate. It's all left over from the tax protest movement. I would, for one, would appreciate if people would stop sending me links to things that I have to then go look at, and the first thing I see is redemption or verify your birth certificate, or all the same things we've already talked about are illegitimate. They don't have any new tricks up their sleeves, although I'm sure they will soon. But right now, no, this doesn't exist. We are examining a complete mythology that is based on this tax protest movement, and none of it is legitimate. I don't care what you say. The newest one that people seem to be flocking to is the discharge your debt one, which is an old one brought back. Same thing, completely illegitimate. You're breaking laws. And these guys never get in trouble for guiding you to break the law. And I don't understand that unless they're protected. I can't figure it out. I cannot figure it out.
Okay, so I wanted to go... well, before we get into picking apart Kale's theories about trust, let's talk about the case, okay, that we found. Now, Clint, I think you wanted to share yours because you highlighted, so I'll let you share yours.
I did. It's funny because there was so much to highlight that it was it was pretty hard not to highlight everything, really.
Yeah,
which was kind of funny to me.
Which is fine if you did, but
I mean, it really does cover most of the frauds out there in this case, where there's a case referenced for each fraud or each false claim or frivolous statement or, sovereign citizen this or that. It's pretty amazing, actually. And what's going to happen is there's going to be, at some point, this pool of cases and precedents that judges, like I said, aren't even going to look at the cases anymore. They're just going to instantly recognize these arguments and dismiss it like that. Or they'll instantly recognize, like we pointed out before, Anna von Reitz, where the judges, specifically called her out for being a fake judge with very, very bad rhetoric and bad legal language. And really, that's what this boils down to is, I mean, the guy is not establishing, I'll tell you what it is really, is that none of these guys ever follow the rules. There is a document that you can go to online. It's called the Rules of Court Procedure, right? That is what you're supposed to follow in these situations. And these guys do not ever follow the rules of court, the federal rules of court procedure, I think is what it's called, right? And this would be like going to a soccer game or something and picking up the ball and running to the goal and throwing it in and saying, What? It's legitimate, right? Isn't that the way football works? Because you don't know the rules of the game you're trying to play. And therefore, if these guys are shown in these court documents not to know the rules of federal court procedure, I mean, for God's sake, why do you think they're teaching it to you? What makes you think you're going to be successful if they don't even know the rules of the game they're teaching you? It doesn't make sense why you guys keep supporting these guys and hating us. And the other thing, while we're going through this, keep in mind, we are the devil's advocates here. We are taking the side of the legal purview because that's what you have to do, and you're expected to do that while you're in a situation that is a legal one. You're not there to try to prove something exists or doesn't exist or that there's a history of that. They already know everything. They amuse themselves by letting you talk about it, but then they tease people. They make fun of these patriot mythologies, and it's actually sometimes fun to read that. But trust me when I say there's nothing new that you're going to introduce to the court. Now, as far as everybody joining up on these groups, right? And oh, I'm in Alphonse's group and we're going to do this. Or I'm in KL's, I'm going to do KL's paperwork. That I have to do it all myself for some reason. I could have paid an attorney to do it for me and it would have been correct. Doesn't, well, no, let's go the hard route. Let's go the incorrect route, right? I mean, I don't know what to say except if you look at this, they're going to tell you all the things it's deficient in. And that's what we're trying to explain to you, is that when you're trying to do something like this in their system, it's not a system that you decide what the rules are. It's not a system that you get to declare law or get to declare. One of the big ones is the silence thing. They didn't answer me, and therefore it's now law. You're not a lawmaker. You don't make a contract that way. That's not how it works. If someone tells you that, instantly know they are a fraud, because they're depending on the not answering to give the illusion that it's working. It's the oldest, that's been going on for 50, 60 years, and nobody ever wins that way. Nothing ever happens good that way. And usually it takes 10 years and your house gets taken, or you get this massive tax lien or bills or whatever, or you go to jail. It's felony, right? Because you're actually committing a felony by submitting incorrect or frivolous paperwork. And it is the opinion of the court, and it's the opinion of a lot of people in the court system, that people like you should go to jail for feloniously submitting frivolous paperwork and taking up the court's time. Meanwhile, the woman that got raped, or the woman that, these people don't have time to actually go into court because they're so busy with sovereign citizen crap. So pay very close attention to what's being said in this very well presented, very short, very concise thing. Something else these guys don't do. Just make it short and concise. Oh, are you muted there, buddy? Jeez.
So let's get into what's going on here with Thomas Peter Wentland.
Thomas Peter Wentland.
And it looks like it's pretty recent.
AKA KL Mr. Beneficiary. No, I mean, okay, why does he call himself KL? Because he does not want you to find this.
Yeah. So I had a lot of people ask, what's up with the John and Jane Doe thing, right? So basically, KL here was trying to sue the government. And his claim was that, hey, I have equitable interest in the name in his estate that is called Thomas Peter Wentland. And this gets into the belief that about the secret trust. You're worth millions of dollars. You can access it. You can use it for, equitable relief and all sorts of different legal matters. So that is what's going on here. So anyways, he names government officials and organizations, but then addresses them as John and Jane Doe, okay, which is very strange. So,
well, not really, because what he's trying to establish is that these are persons in law that are suable, whereas you cannot sue Secretary of State. You cannot sue. These are offices of a single entity we call government. You're trying to sue the person behind the office is what he's really trying to accomplish. A lot of the times, and then a lot of times they're trying to establish that there really is a Secretary of State, there really is a king, there really is a president, and that president is a person that is suable. And yet all of these people even the Constitution says they're immune, right? Read your Constitution for once, and maybe that'll, satisfy the fallacy that these people are suable in office. No, offices are not things that you can sue. It's not, doesn't work that way. Not for purposes of this, right?
Right.
Of attaching this sort of criminal
Yeah.
conspiracy to.
Yeah. So this is, he calls it the petition for declaratory relief enforcements of trust and bill of equity. I mean, what a mouthful there. So let's continue reading through this. Clint, if you want to scroll down.
Uh, oh wait, there again. John Doe and Jane Doe's number 1 through 99, who may have an equitable interest in the name and estate of Thomas Peter Wentland. On the same day, plaintiff filed a motion to seal this case, which I find is hilarious. And yeah, of course, because I don't want you people to find this. But there's your John Doe's. Now, interest in the name and estate, right? I mean, he's the one with an interest.
Right.
They're the holders. Like they're the landlord. They're the feudal lords of his name and estate. He has a claim as a claimant, which he calls himself. Again, that's like saying a slave is a master. No, you're the claimant. Where you're making a claim to a higher authority. Do they have an interest? Absolutely. But they have the holders. I mean, it's their name and estate, not yours. The only reason that you're calling it yours is because you're like the manager. You're like the middle manager of your own estate. That you're not anything higher. It's not sovereign. It's not yours. It doesn't exist in reality, right? So you can't think that way.
Yeah. So, so this gets into, because remember, he was berating me, saying that I'm the ridiculous one for not going with his narrative that what he's doing right now works. Okay, so he starts this whole thing with the state of Illinois, because apparently that's where he was born. And yeah, he's citing the Social Security Trust Fund. So yeah, he's really trying to cash out here, it sounds like.
I'll just read it because I think it's worth reading the whole thing, honestly. What do you think?
Yeah, I mean we can.
I mean, at no point does plaintiff specifically identify the Doe defendants. I'm going to shoe people that I don't identify. However, the defendants appear to be various government entities that have referred to the plaintiff in all capital letters. Okay, again, this is called style. You can look at the style manual. Every art has a style, okay? We write things either capitalized or not capitalized, etc. Has nothing to do with the existence of the name. The capital letters, yes, corporations are generally printed in capital letters. That's a style that is a recommendation and often an enforced recommendation. It has nothing to do with anything. As far as the legal code, it is only the way that we write terms of art. That's it. Nothing else. And that is, I lost my season showing that, but I mean, I looked it all up. Plaintiff asserts that by their silence, again, here's the clue.
Yeah.
By their silence, the John Does, the government, they agree that he is the heir and sole beneficiary, government, the trustees, of Express Grantor 1789 Trust as the Constitution of for the United States of America. Wow. He is the heir and sole beneficiary, government, the trustees. He's the government and the trustees. Is that what he's saying? And the sole beneficiary?
Yeah.
He's the trustee and the beneficiary of an so I mean, where does that leave all of us? Of Express Grantor 1789 Trust as the Constitution for the United States of America.
What's funny about that is, let's assume there actually was the 1789 trust back then, even if it were a legitimate thing. Back then, you had the rules of perpetuities.
If your foundation is flawed, then your superstructure will be too, right? Everything you build on your flawed foundation. This goes back to it used to be called the Constitution for the United States, the way it was originally written, and then they changed it the Constitution of the United States later on. I mean, it doesn't really. It's not what people think, because remember, the constitutions are international appeals, and basically, it's almost like an application to enter into the New World Order, the global government, according to the Treaty of Westphalia. Every country in the world creates a constitution in order to enter into the United Nations, etc., whatever it was before United Nations, League of Nations, and then back, for however long this has been going on, 1,000 years, 2,000 years since Rome. So, in other words, this area that we called the United States for the United States of America, right? We called it the Confederate States. Well, that was incorporated into the global government. Okay, really didn't see the power behind that until the Civil War, when the Confederacy decided they wanted to make their own nation state by seceding from the Union, thus essentially trying to steal the land of the United States. And of course, they went in and beat their asses, including Texas, and said no, and the law still stands. If you do this again, we're going to come in and conquer you. That is written law. I covered that in my first Red Pill Sunday School season. It's not a joke, right? The whole idea of California seceding and all these things. No, you cannot secede because the states have pledged their lands to the United States. We're not talking about some romantic history here where there was a United States and then there was an illegitimate United States. No. It's not. That's all patriot mythology. I've disproven it many times. So if that's your belief, well, then you're going to write it in here as a 1789 trust, which was the Constitution for the United States of America. Then you're gonna write stupid shit like this, and the courts behind the scene, they're laughing. They are laughing at you because This is so incorrect. So incorrect. It's not a trust. Now, you might say we're in trust, or but these are colloquially. They're not meant to actually suggest that it's a trust, right? That's not how this works. So you're just completely off here, and so everything else, therefore, would be off. Also, the fact that he says he's the heir and sole beneficiary and the trustee of this non-existent trust.
Yeah.
Right. That wasn't made for us. It was made. The Constitution's made against us, not for us. It doesn't.
Yeah.
It's not for the common people. We all came over here as indentured servants. We weren't the people. We weren't these. This is all based on a big, fat patriot mythology.
It has zero components of a trust.
No, and it has zero components of truth. That's that's why. And they'll say that. Also names Winnebago County, Illinois, State of Illinois, the Chancellor in Chambers, and the Social Security Trust Fund as possible respondents, but doesn't use their names.
Right.
The court construes plaintiffs' pleadings liberally, and sua sponte concludes that they do not contain any claims upon which relief can be granted. And this is extremely important, right? I mean, we're talking about, you're asking a court to do something that it doesn't have the power or jurisdiction or reasonable legal whatever to do, right? Because these things don't exist.
Right. Accordingly, we see this theme over and over.
Over and over. Accordingly, plaintiff's action is dismissed for failure to state a claim upon which relief may be granted, and as frivolous. It's always frivolous.
It's always this exact sentence.
Right. There is no relief for someone who believes they're the sole heir and beneficiary and trustee and government of the Constitution. I mean,
he basically took the whole world and made it an internal object for himself.
Right? I like you really, I mean, talk about sovereign citizen. I mean, look, that's another word for that would be sovereign slave, okay? Sovereign
Yeah.
conquered individual. No, this does not, none of this is true. So, no, the court cannot grant anything about it or in response to it. I mean, it's, God. That I once believed half of this shit is what bothers me, because I did. I mean, I was an ignorant fool. I didn't do my own research. I listened to gurus until I started doing my own thing. And then, and unfortunately, that was pretty quick into it because everything seems so ridiculous.
And then you met the young Asian guy.
Oh, yeah, no. Then I learned about all this trust stuff, the real stuff. You got anything more to say about this?
No, I mean, it's pretty cut and dry.
I love it. Filed a motion to seal this case.
Oh,
Please don't show it to my victim. I mean, my listeners, my supporters.
my students is what he says.
Yeah. Pleadings. Plaintiffs' pleadings make little sense. Now, to you listening, maybe they do make sense because you believe
Right.
in a false narrative, right?
He's using
But-
the frequency heuristics that they want and you're used to hearing.
Exactly. So to a legal professional, someone who professes the legal language and law, this makes no sense because, one, it's not true. Two, it's completely irrelevant to any type of, as he said, there was no actual relief requested. There was no, this was just a nonsense thing. So, and later on, we're going to find out he didn't even know which, they didn't even find it. There's no jurisdiction listed, right?
Yeah.
But, his pleadings made little sense. He argues that 9 days after his birth, somehow he knows that 9 days after his birth, the state of Illinois, the state being this giant monster that came in and, right, who's the state of Illinois? That must be John Doe number 52.
Right.
Come in, he created the quasi-corporate artificial person, Thomas Peter Wentland. No, actually, your parents submitted an application form of certificate of live birth, and the birth certificate was created from those vital statistics, thus creating a status or citizenship in the United States. So you're plucked out of the state, put in the United States, and that's where your law is now. That's all. And the fact that he is submitting this case in the name of Thomas Peter Wentland and not KL Mr. Beneficiary means that he's acknowledging that this person is his third party that he's an agent for, and that the government is, as a pleader, as someone who's making a prayer to the God of the court, right? He's admitting there's no other way he could have had this case heard other than by doing it in this name that he, believes is a sole corporation
Yeah, which we'll later get into.
granted into the private constructive Sesquicu trust, which we covered,
Yeah.
PCT. Thus, petitioner became the quasi-surety volunteer quasi-trustee for the Sesquicu trust, presumed decedent legal estate trust. Wow. Like, it was almost like he picked some words out of a hat.
Yeah.
Okay, so, do we break this down? We did a whole show on the Sesquicu Trust, which was 1666, which has nothing to do with, and now it's a term that's used, but there's no trust. Okay,
Right.
That's not how it works. We'll just refer people to that show unless you want to say something.
And it's
about
important to get into what is a constructive trust. Let me share my screen and I'll show you guys. Let's see. So constructive trust, because this.
Let's see, do I need to stop sharing? Or?
No, Constructive trust is not an actual trust by the traditional definition, but a trust created through a court's power over assets they determine a party cannot equitably keep. It is a legal fiction that is used as a remedy for unjust enrichment. Hence, there is no trustee. I'm gonna read that again. There is no trustee. Now, this is important because this is completely different than the type of trust you're probably thinking of. You're probably thinking of, the type of trust that someone like Rockefeller would use, right? This is completely different, as this is saying. This is only created through a judge, not an actual trust. So let's just create a hypothetical scenario where, let's say I steal some money from Clint and I buy an asset with it.
Bastard.
And now I'm in court. Clint takes me to court. Thank you very much.
This is a crime called conversion.
Yeah. And so now the judge says, you know what, Brandon, you bought that asset with Clint's money. I need you to sell that asset now. And so I'm gonna create this constructive trust. So you sell the asset and now the money goes to Clint. That's it. That's all it is. There is no trustee because the judge, that's all he's doing.
And by the way, that's not equity.
No.
If it was equity, I'd have you go do 30,000 hours of public labor.
Yeah. Right. So it's important to note that because if we go back to, Clint, I think you'll need to share your screen again. But if we go back to what Kale was saying here, he was saying that he was the trustee of this private constructive trust that is the Sescuvée Trust.
So in other words, way back then, they thought, which American in the future do we want to be the trustee of the whole?
Right.
I mean, yeah, right.
It doesn't make any sense. So now this guy claims to be the expert, or at least he wants to come off as the expert on trust, right? But he doesn't care to define or mention what a constructive trust actually is here, right? But
these are the guys that are saying everything's a trust. Everything is a trust, right? I mean, everything that is an agreement or even a myth is a trust, right?
Well, I saw one. It wasn't KL, but it was a lady we were covering. She was saying even the buying gas at the gas station is a trust. It's ridiculous. So, okay, so we cover what the constructive trust is, not what this guy's saying here. Now, surety, voluntary, quasi-trustee, there is no such thing.
Well, I mean, you are in a position of suretyship and volunteerism, which means the master and servant or principal and agent. But
that's not a type of trustee, though.
No, that is he's referring, and this is sort of correct. He's referring to his person, in other words, to Thomas Peter Wentland, the person, right? Which he's in surety too, right? And he's volunteering to do so, which is a weird way of saying it, but I mean, okay. I mean, it takes you to volunteer. I mean, it's not like you don't create a volunteer. You actually have to like he's using the name here to file this case, he's voluntarily using it and is in surety and bond, which is why he's in this court.
Yeah. Okay, so let's continue. Well, actually, before we continue, Trading with the Enemy Act. That's one of his main highlights people get from him. But Clint, have you looked into that?
The Trading with the Enemy Act?
Yeah.
Yeah, I mean, it's part of the mythology, but there's also something to it. They actually explain what it was in here, so I'll let them do it. But it was basically when we were in a situation of war and the United States was eminent domaining, essentially, or under war powers taking land and property and stuff. It was a way of getting your stuff back, but it's also, see, what was special about it, what this guy apparently doesn't understand, is that it made us all potentially enemies. There's alien friends and alien enemies. And it gave us all the potential of being an enemy of the United States, by trading or doing commerce with a foreign country that the United States is at, odds with or at war with. Technically, if they wanted to, they could say anybody who's done business with China is now an enemy of the state. In other words, right? If they declare it, and so you'd have to stop doing commerce or you'd be declared an enemy of the state. So it gives the potential to all citizens of becoming an enemy of the state if you, right? So that's always looming there. It's kind of a strange thing, but it also tells you that you're utterly controlled and that you're not, that you're barely hanging on as a non-enemy, right? You're an alien friend. So to be held in trust. So this artificial person was thereafter seized under the I've never heard that. To be held in trust by the President of the United States. There again, as if the President of the United States isn't actually a person, right? It's an office. So, it wouldn't the president doesn't do much but public relations, right? It's not him doing anything. It's, you could say the government, but to say that it's a trust, again, citizenship is not a trust. It is a voluntary suretyship, absolutely. And this is why I laugh at everybody who says they want to live in a voluntary society. In fact, I just did a show where I cover that. But
that's funny.
It's again. This is why I say there's some truth mixed in there in a way that it's barely visible.
Yeah.
And this makes me kind of believe that there's just some evil intent here, man.
There's got to be. Now, why is Kale so confident about this PCT, the Private Constructive Sesquive Trust? Well, this is a quote from his response video of our video together, Clint, about him. He was defending that, the corporate sole straw man is placed in the public trust, is the one he's talking about here, in the Congressional Record 1967. Okay, so I went ahead and looked up this Congressional Record 1967. Okay, let's see if there's actually anything there. So I look it up, and you can do this yourself. It's free information. And nothing in this talks about the straw man, the natural person, trust, Sesquive, none of that, of course. In fact, that record doesn't even exist.
Well, it's not necessarily that he made it up, but he probably got it in an email or something, an email dump of all these facts. And then when you go to check the source, they're not true or they're not there, just like this. I've gotten several of those. And you have to waste your time disproving it because you want to believe these things, but they're just not true. And they're often not on the record. So
yeah, that's the other thing.
It's just, like I said, I can't tell you how many things I've had to debunk because it's just not an officially recorded. They'll quote it as if it's officially recorded, and most people won't verify the source, which is the problem.
Yeah. Okay, so let's see. Let's continue here reading here in this Kale case.
Let's see. Plaintiff thereafter abandoned all interest in the state-created, so now it's a state-created, federally protected artificial person, ends legal Thomas Peter Wentland. Plaintiff. Okay, so he's saying that he, whoever he is, because he's obviously not Thomas Peter Wentland, abandoned all interest in the state-created, federally protected artificial person, Thomas Peter Wentland. He abandoned all interest, but he's appealing to the court in that name as surety for it. So, no, this is what I'm saying. You wouldn't, if you abandoned all interest, you wouldn't even be here in the first place.
Yeah.
So plaintiff asks the court for injunctive and equitable relief, including a notice that any entity with an equal or higher equitable claim concerning the name and estate of Thomas Peter Wentland show cause why relief should not be granted, and a declaration that plaintiff is the sole owner of the name Thomas Peter Wentland. I mean,
sole owner.
could I go to the phone book and then like sue all those people because I'm the sole owner of all? And here's, oh look, there's 10 Thomas Peter Wentlands in New York City. I'm going to sue them all because I'm the sole owner. I mean, this
Right.
again, this is the stupidest thing. Notice that he uses capital letters too.
Yeah.
Well,
Right.
wait a minute. You just got done, arguing that they made it in capital letters. But if they made it and it's theirs, how can it be you that's the sole owner? I don't get it. You didn't create it.
Well, and that's the other thing. I'm like, how? So you mentioned the beneficiary trustee of this Sesquive Trust or whatever, Thomas Peter Wentland Trust. But now you're saying that Thomas Wentland itself, the individual, is the owner of the name. That doesn't make any sense.
Well, I mean, because then what are you saying the name is?
Right.
What is
yeah.
is it some form of property? Because if you're talking about a God-given name or what they call the Christian name, well, then you can go by Thomas and get rid of Peter Wentland. And now you're using only what the legal system calls the Christian name or first name, and you've ditched the surname, and you do things in that. Well, okay, well, at least that's a start, right? At least you understand what's happening here. But you want to own the full legal title as if it's a title. You want title to the name. You want title to the title. And that is, there again, it's... So I think what he's doing here is saying that Thomas Peter Wentland, because up above he said it's the name and estate. Mm-hmm. So I think he's trying to say that he's the sole owner of the estate that is under the name Thomas Peter Wentland.
Right.
But as we know, common people don't own anything. So anything that's under that estate is property of government, and he's allowed to be a usufruct, basically, pay tag, So no, you're not the sole owner of the name or the estate. Okay, but
well, and it goes on. Plaintiff's filings are difficult to decipher and contain completely irrational and incredible allegations.
Which is what I'm trying to say.
Because plaintiff's pleadings are incomprehensible, it is impossible to determine whether venue is proper in this court.
No. How do you establish a jurisdiction with a claim like this? Where would this possibly be?
Right.
A good venue. I mean, except maybe the insane asylum, right? Because none of this is true. How can you establish a jurisdiction? It's a frivolous claim. There is no court for frivolous claims.
Yeah.
So, and again, this is the court. So remember, we're playing devil's advocate here. We're saying, okay, the devil made the rules. Devil's another word for attorney, by the way. And if the devil is saying this, and we're also showing it at the same time, you can't. I mean, you don't have to be a devil to see that this guy is actually the true demon here. I mean, that he's leading other people into God knows what.
Well, I mean, we see this trend with these guys time and time again, where they make statements in these documents, but no actual basis in law or in fact, like the standard review says. So,
but I think there again. If you had an organized group made to look unorganized, this would be perfect. If you had a controlled opposition that was designed to trick people into following all these gurus and who would otherwise be the remnant, who would otherwise be this great people who with all the power, but instead you keep the knowledge from them by giving them false knowledge, exactly what's happened in America and the world, for that matter, right? We've been dumbed down in ways that are unimaginable, practically. Although Charlotte Iserbyt did a whole dissertation on it, deliberate dumbing down of America. Gatto did it. They're both in the teaching profession, right? Charlotte Iserbyt was the Assistant Secretary of Education, for God's sake, and she wrote a whole book on how Americans are dumbed down. So it makes sense to me that you would put these kind of statements in that are frivolous and non-compos mentos, basically, that would drive people who would otherwise be successful, otherwise be hiring an attorney, otherwise be studying the law and actually practicing the proper way, the pro se, or whatever method they're going to use. That would actually make a lot of sense to me, to distract them into.
That's just it, though. The pro se thing, which is promoted by both these guys. KL and Alphonse were talking about earlier. Now, KL is not as friendly with Dr. Graves as Alphonse. But
at this point, Dr. Graves has to be called what he is. It's just equally a fraud. I'm sorry.
Yeah, I mean, that's kind of what I wanted to get into, because
we tried to warn him.
Because I don't even want people to think that they should be pro se most of the time.
No, not a system like this.
Right. So we can see it's just, yeah. Okay, so let's continue here.
That doesn't mean that you shouldn't advocate for yourself. There's a lot of advocates out there, etc. It doesn't mean you should just go to any old attorney before, research who you're going to. But see, the thing about this, though, is this is like a proactive thing. This is like not proactive. This is like an addition. Like they're getting you to do stuff that you ordinarily wouldn't do.
Yeah.
Right? And as opposed to going and getting a legitimate will and trust about the only things you really can do, they're creating this sort of fictional landscape that makes you think you're successful even though there's no sign or record of your success. Quite the opposite sometimes. So it's just strange, man.
This just gets stranger the more we read this. Let's continue here. Standards of review continue. Dismissals on this ground should only be ordered when the legal theories are indisputably meritless, or when the claims rely on factual allegations that are clearly baseless. So that's just it. When you can't even make factual allegations,
the complaint is frivolous where it lacks an arguable basis either in law or in fact. And essentially, that's what all of our shows have been geared towards. This is not legal, this is not legalese, and this is not fact. None of this is fact. It's all patriot mythology. And here's the court saying the same exact thing. Now, who are you going to listen to? Are you going to continue to go to these random people that you know nothing about and refuse to research? Or are you going to go to someone in the actual, it just doesn't make sense anymore that people are falling for this when it's... Plus, I will admit there's so much of it out there now, like the copycats and the copy.
Yes.
But and people go so far, and then they say, "Okay, I'm going to start a business because I now know a little tiny bit about this major subject." Right.
Right.
But man, it just doesn't make sense. Legal theories are indisputably. Now, notice what they're saying: to dismiss because it's frivolous, where it lacks an arguable basis either in law and fact. A quote, right, from a different case. Notice all these cases they're listing.
Right.
He says, the judge is saying, look, I wouldn't bring that up except that this case, this legal theory that this guy's developed are completely, indisputably meritless. That's why he's bringing it up. And he's quoting that because, and he's saying that because, look, my hands are tied here. I can't even do anything with this load of paperwork. It's not even viable. It's not arguable. It has no legal basis or fact. Therefore, it is indisputably meritless. And that's what he's saying here. When the claims rely on factual allegations that are clearly baseless, he's telling us that if you go to court with this crap and this false history, you're going to lose. I wouldn't even say lose. It's going to be summarily dismissed.
You're going to be embarrassed.
And they're going to have a good time. They're going to be like,
Yeah, this is what they want. So the court may dismiss a complaint pursuant to Rule 12b-6 if it fails to contain sufficient factual matter, accepted as true to state a claim for relief that is plausible on its face. Okay, so Rule 8 of the Federal Rules of Civil Procedure requires that a complaint include a short and plain statement of the claim. State of claim, right? With simple, concise, and direct allegations. The point of Rule 8 is to give the defendant fair notice of what the claim is and the grounds upon which it rests.
okay, but who's the defendant?
Well,
John Doe 1 through 99, of which are not necessarily publicly listed. Therefore, can the defendant, who is John Doe 1 through 99, unlisted, have fair notice of what the claim is? I mean, obviously not. He wants, what he's looking for is a decision that doesn't consult with he who he's suing. That would not be justice in any way.
Yeah, I mean, this guy talks about equity all the time, right?
Equity.
This violates so many concepts of
There
equity.
again, go back to our show on equity, and
Yes.
you'll have no doubt what the equity and the court of record, the court of equity, they've all
Right.
been merged together. There's
He claims that equity court and regular court are separate, and I'm a special boy. I go into equity court.
And look, persons are generally not considered in equity.
Right.
Persons are commercial. Commercial doesn't deal with equity.
Yep. It's usually going to come down to financial matters. And equity, here's the thing about equity court. And now I highly recommend you guys go back and watch our equity show. I'll link it below. But a quick highlight. Basically, like Clint was saying, ever since the 1930s, the two courts actually came together, the court of law and the court of equity. So now it's merged into one court. And it makes sense, right? Because in some cases, there is no legal precedent. Like, for example, if you have a family court situation, it's situational, a lot of this stuff. Or the example I shared earlier where I steal money from Clint gets equitable relief, So things can be so individual, idiosyncratic like that in these cases where there is no legal precedent. So in equity court, the judge, and when I say equity court, just remember, both courts, same room, the judge becomes the law in equity. So it appeals to the emotions of the judge and his decision-making, right? And that's the last thing you want in this system.
Well, for monetary matters, yeah, that's the other thing is generally equity does not involve monetary reward or compensation. Equity would be, it's almost the moral court, if you will. It's almost like saying, well, because you did this wrong, you're going to do this right, right? It's not. It's an attitudinal and physical type of. It's not even a punishment. It's an actual equitable redemption, if you will. Whereas monetary relief, you're not really getting anything but this artificial thing. It's not really fixing what you damaged, right?
Right.
So in equity, it's generally not a monetary, it's not dealing in money because money doesn't fix it. There's no love in money. It doesn't buy you love. It doesn't, right? There's nothing good about money in that sense. You can't replace what was broken. Money certainly won't, but maybe we can rebuild. Maybe I can do it for me, right? Maybe I can act. It's the way law really, I mean, honestly, it is the way law should be. And it does include, when we say that equity and, the commercial jurisdictions are merged, really what that means is that the maxims of law are considered. But when you go to court as a person representing some commercial entity, you're never going to find equitable jurisdiction because you're not in it. You're not in it. You're in a money-based jurisdiction, which is what 999 times out of 1,000, or maybe 1,000 out of 1,000, is always going to be in that court of court of record.
Okay, so a shotgun pleading where it is virtually impossible to know which allegations of fact are intended to support which claims for relief does not comply with that standard. So let's continue. Rule 10 of the Federal Rules further provides that if doing so would promote clarity, each claim founded on a separate transaction or occurrence. Right, so that's the thing. Again, he's just giving a statement, and nothing like this rule is looking for.
This is almost like he's doing a radio show in court.
Right,
like giving a short little shout out to the SSQV and shout out to the, but not actually making a claim thereby, right? And it is true, yeah. And this is the way these big omnibus bills are such a problem, because there's so many laws being passed at once. Every bill should be its own unique thing, and you shouldn't be sneaking all these earmarks and shit in there, but they do. Well, in a court case, yeah, you'd want to list each one of these things as a separate complaint. The SSQV is here, this is here, and you'd want to put backing evidence, and you'd want to be completely clear, because what you don't want to do, and I think what people don't realize about the courts, especially in this situation, is that the judge probably knows exactly what this guy is what he's trying to say. Okay, yeah. The judge does not have to, and generally will not, according to his rules of procedure, will not offer evidence in your support. That would be an intolerable act in court. The judge may know you're innocent and will not offer evidence to support your innocence. That is not his job. I shouldn't say innocent, because they don't like that word in court. Not guilty. So, yeah, you would want to explain each of these things in thoroughness in order to justify the reason that you're saying. You don't just throw it out there and be like, such good, and expect the judge to be like, oh, yeah, I know what he's talking about.
Right.
And this is anything but simple and straight to the point,
Oh, exactly. Yeah. Rules 8 and 10 work together and require the pleader to present his claims discreetly and succinctly so that his adversary can discern what he is claiming and frame a responsive pleading. The court can determine which facts support which claims and whether a plaintiff has stated any claims upon which relief can be granted. And at trial, the court can determine the evidence which is relevant and which is not. If the court concludes that a plaintiff's complaint does not meet the requirements of Rule 8 or 10b, it may dismiss the complaint. Okay, so it goes on for failure state of claim. Okay, so that's the thing. That's the common trend of all these guys. They never can state a proper claim. They never have a proper state of claim to begin with. It's usually some type of civil rights code, that, or at least for Alphonse, that is. Now, KL, he believes he is beyond statutes and codes.
Not liable for any state code, statute, or act.
And as we continue further into this, the more it becomes clear that he is, in fact, under these statutes and codes. And this is what the judge is describing.
If you're claiming civil rights only apply to a person. The whole point of civil rights, the whole point of giving a person, for instance, to the 14th Amendment citizenship to black people was it so they couldn't, you were actually giving a civil status to people so they could no longer just take them out and hang them on a tree. You'd now be hanging government property. You'd now be, taking away the potential wealth extraction capability of that slave, who's now a person of the United States, a voluntary slave, just like we are. So you can't, you're not, just come on, guys.
So, pro se complaint complaints are held to less stringent standards than formal pleadings drafted by lawyers. Pretty known fact. Nevertheless, pro se litigants are not exempt from complying with the federal rules of civil procedure, including 8A2's pleading standard. So this is another pattern we see. Even the ones that claim they are masters of court procedure and the rules of procedure, all that kind of stuff, they still will make mistakes. And the judge will often say something like this.
They're saying we're dumbing down the court for these people, basically.
Yeah.
We're not expecting the professionalism that we'd see and expect from our general counsel. No, we're going to dumb down the court and consider perhaps some of the common language that's going to be inserted in place of the legal language and try to understand what they're actually saying. So they are actually kind of giving you a break here is what they're saying. But, you're a fool. I mean, it's just like going into a debate with a scientist and not knowing the terms of art of the science you're going to debate. Doesn't make sense. Because remember, you're speaking dog Latin, the common language. There's a set in between, and the highest language is law Latin. That is the high language. That is what these guys speak. And it is so far above any of these idiots that you call teachers that, obviously they're telling you that. So, and they're certainly far above me, and I study it a lot, right? So I don't claim to be an expert at this. I just know enough to stay out of court. Like, I don't want to do anything with this, right?
Yeah, so basically they're saying, even though we gave this guy leniency, even in this case of the pro se litigants, this leniency does not give a court license to serve as de facto counsel for a party or to rewrite as authorized deficient pleading in order to sustain an action.
So there again, the judge will never come to your defense, is what he's saying. He's never going to present evidence or say, oh, you mean this. Oh, here, let me pull something up for you and present it to myself. No, you're either prepared or you're not. You're concise or you're not. And this is absolute foolish gibberish.
Yes. Stating that pro se litigants are subject to the relevant law and rules of court, including the federal rules of civil procedure. Okay, so remember, Gale supposedly was above all this stuff. All right, let's continue reading this.
We're now in the analysis. Remember, this is the rejection and dismissal of KL, Mr. Beneficiary's case here. So this is the court analysis.
Even liberally construed, plaintiffs' bill and equity filings are confusing, incoherent, and unintelligible. The pleadings do not comply with the Rule 9 of Federal Rules of Civil Procedure. They do not state simple, concise, and direct allegations against any defendant. Plaintiffs' filings also fail to state a claim against any defendant that is remotely plausible on his face.
Again, you're entering into something you know nothing about, using a common language when you should be using their terms. This is like showing up to a surgery as a nurse and not knowing what a scalpel is. I mean, seriously, I don't know what any of these tools on. You want the sharp one? Oh, you want the one that looks like scissors? Right? I mean, that would be similar to this, basically, is what they're saying.
I mean, imagine this guy's face hearing the judge tell him all this. I wish I could have seen that. Plaintiff's complaint makes repeated reference to the Trading with the Enemy Act. Was enacted to allow allies and non-enemies to recover property vested with the United States government during World War I and II. Plaintiff does not allege facts showing that he has any right to relief pursuant to the Trading with the Enemy Act, dismissing a complaint with prejudice where the pro se plaintiff failed to state a plausible claim pursuant to the Trading with the Enemy Act. Okay.
So again, he mentions it, but he doesn't get into what he's talking about. So they have no idea. Even if they do have an idea what he's talking about, I'm sure they do, they're not going to help him out here. And
how could they?
The guy wasn't even a sperm during World War II.
Right. Yeah, let's continue here. Plaintiff also cites the same act, the National Emergency Banking Relief Act. Oh, we've talked about that. Clint. Codified at 12 U.S.C., was passed by Congress in 1933. So this is the
How many times do you hear 1933? That was the magical year.
Right. It deals with the solvency of banks and the operation of the Federal Reserve. Is okay. This is basically them saying, look, this is showing that the government is bankrupt, right? And Clint and I have gone into depth in our Federal Reserve video that's on my channel, the Brandon Sterling channel, talking about who actually owns the Federal Reserve. And it gets into how the government is actually not bankrupt. And, you know, the beliefs around this 1933 bill, this act, I should say, is completely false, including the beliefs around
no
the Fed.
bankruptcies. No, again, now me laughing at this and making fun of this, I have the benefit of being one of the fools who believed this and who actually then turned around and wrote about it as if I knew what I was talking about. So when I'm making fun of people, I'm making fun of myself just as much. Okay. Yeah. I want people to understand that I have the right to call you people out because I was one doing this. I am now remedying that. I am now fixing any problems that I might have caused people or beliefs, false beliefs that I caused people. And it's time for you to do the same and to get out of this criminal business that you're in.
Yeah. So nowhere does he give a connection between the, National Banking Relief Act and his relationship with this trust. Notice again, just statements.
I wonder if the Emergency Banking Relief Act was also a trust.
Well, apparently, yeah. Everything's a trust, remember?
Yes. Well, money's a trust. And
oh, yeah. Forgot about that one.
Yeah, so the bank has to be a trust because it handles money. That would be the logical conclusion.
Oh, man. Let's keep going here.
Let's see. Dismissing a pro se complaint for failing to state a claim pursuant to the emergency. That's another. So here we have Cleary versus United States, Hardgrove versus Georgia, dismissing as frivolous a pro se complaint based on the Emergency Banking Relief Act. In other words, if you go into court, they're now going to say Cleary versus United States, Hardgrove versus Georgia, and KL versus the unimagined, unpresented John Does. I mean, it's going to say the same thing. And that's what I want people to understand here is this is an ongoing fraud. And they're quoting the cases that prove that this is an ongoing fraud.
It also appears that plaintiff may be attempting to raise a claim that he is a sovereign citizen, not subject to the laws of the United States of America. And I already hear people in the background say, "Oh, the irony! You can't be a sovereign and a citizen."
Sure, but I mean, let's be honest with ourselves. We once believed it ourselves. Otherwise, we would never have really even known the notion or concept of a sovereign citizen. So you have to admit that you believed it at one point before you can have the right to tease people for it. Right? It's just because that feeling of belief is very powerful.
Yeah, and he files this as what was it? A pre-1933 private citizen. We'll show that.
I'm a pre-trust based on a former trust that was, like, which trust am I?
So he will be included in that group of people that will deny that label. But this is a clear example, even with the verbiage that KL uses. The courts are still going to call you the sovereign citizen.
You don't have to say, I'm a sovereign citizen, and therefore all his language is the language of someone who believes they're a sovereign, a god who rules over other people, and also a citizen, a denizen, someone who has no rights to land and anything, that is a voluntary slave.
Because that's why he's in court.
Right, and there's that's the thing that is so funny about it is the contradiction in terms, sovereign and citizen, two completely different, right, left and right, boss and employee. There is no connection there except that one rules over the other. It's not that he's calling himself that, and sure, he can say, in honesty, he can say, I'm not a sovereign, I don't call myself a sovereign citizen, but everything he says is someone who's a citizen that's considering himself sovereign.
Yeah.
Right? You don't have to have the title to make the claim.
And they've seen these arguments, and they continue to say, however, the courts have considered sovereign citizen claims, have found them to be frivolous, recognizing that courts routinely reject these claims. The issuance of plaintiff's birth certificate did not create a fictitious legal entity simply by capitalizing letters in plaintiff's name, and it did not turn such artificial person. Notice that they said artificial person. KO likes to say he's the natural person a lot of times, right? And a lot of these gurus do.
Which is a legal term referring to the
individual.
Right. It doesn't mean anything.
Yeah. It did not turn such artificial person into an enemy of the state under the Emergency Banking Relief Act of 1933 or the Trading with Enemies Act. Moreover, plaintiff cannot bind these defendants to his fictitious notions by arguing that respondents, by their silence, agree to these facts. The courts have repeatedly rejected such redemptionist, there's that word, arguments as utterly frivolous. Theories presented by redemptionists and sovereign citizen adherents have not only been rejected by the courts, but have also recognized as frivolous and a waste of court resources.
Now, what do I keep saying? I now call the truth movement or the patriot movement, the text, I now call it the false redemption movement because you're looking for redemption in all the wrong places.
All right. So, yeah, they're really ripping into this guy.
No, they're ripping into what they should rip. I mean, this is a very well-written. I have no problems with the way this is written.
Oh, I don't either.
I'm just saying it is actually not even negative towards him. It's negative towards what we're negative towards, really. So, I mean, like I said, we're devil's advocates here, but only because, when you're dealing with these people, you got to use the correct language. If you're dealing in UCC, if you have one word misspelled, you're going to fail. I mean, it's that strict. So you don't do it yourself. And if any guru is selling you anything and says, do it yourself, follow my directions, if you don't follow my directions, and all of these key things that are in this case, you got to wait. If they don't respond, if there's silence, then you win. And then you can do this. And another one is the fee statements, the fee schedule of fees, right? Fee schedules. They're all bunk, guys. They don't. You cannot give someone a fee schedule and then later sue them when they
or a notice of liability.
It doesn't work that way.
Yeah.
You're a person of the United States. They're detaining a person of the United States. The law of persons of the United States is United States code, not a fee schedule.
Yeah. So, I mean, this is kind of repeating what we read up there, a little repetitive. They're just, again, calling this guy sovereign citizen.
Well, you know what? Repetition is good for people.
Plaintiff's action is frivolous and does not state a claim upon which relief may be granted. Amendment is not permitted as it is apparent from plaintiff's pleadings that granting leave to amend would be futile.
Because, why? Because pursuant to Rule 8 of the federal courts, they're not following procedure. Why would I give you another chance to not follow procedure? You're not going to. Why would I give it to you?
Yeah. It is hereby ordered, dismissed without prejudice as frivolous and for failure to state a claim on which, scroll down, on which relief may be granted under Rules 8 and 10 of the Federal Rules of Civil Procedure. The court is directed to terminate any pending motions, close this case, and enter judgment accordingly. Done and ordered in Fort Myers, Florida in 2022. So, pretty recently, 3 years ago. And has KL mentioned this anywhere? Of course not.
You can dictate the court proceedings and what kind of judge you're going to get and what kind of rules they're going to play by. And it won't be the regular rules because, again, trusts are a special thing.
So
does he say, I don't remember, does he say he's in Florida?
No, he doesn't share where he lives.
Okay.
No.
Again, I want you to notice, though, in these, yes, it's dismissed without prejudice, a word you should not be using, a term you should not be using. amendment is not permitted as is apparent the plaintiff's pleadings that granting leave to amend them would be futile. Notice that they list cases. What you should be doing, not just listening to us, but pulling up each of these cases that we're showing you right here,
Exactly.
that are right in there. They're quoted there for a reason, the same reason that when you go to a legal dictionary and you read the definition of a word, that definition is the latest, generally, the latest definition taken from the latest court cases, if it's a good dictionary, okay? The latest opinion of the court, which is like a people, right? The generality of the court. Affirming denial of pro se plaintiff's motion for leave to amend based on futility of amendment. There's the case. In this case, affirming district court's sua sponte dismissal of sovereign citizens' complaint as frivolous without. Go read these cases, because when you try to file your case, guess what? It's going to say the same thing. And you know what?
Yeah.
If you really want to learn, then you'd read these. That's what lawyers do. In order to
Right.
be a lawyer, you read case law. You don't sit there and you do what I do, which is to study words. I'm not interested in being a lawyer, so I don't. I do read case law, but not like you're supposed to when you want to be a lawyer. And all you're really doing is learning how to copy other lawyers. You're not learning the ins and outs and intricacies of law. You're learning how to act in court. You're learning procedure. You're learning this. But you're, as people in this so-called truth movement and tax protest movement and such, now it's the trust movement, the redemption movement. You're not learning case law. Notice that even while we're speaking, we're reading a case right now, but we're not covering each. If I was reading this as a legal scholar or a legal student, I'd be going to each case for reference. But see, I don't know anybody in this alternative sphere that would even look at this case, because the desire to believe that this is true is higher than the desire to disprove it or to prove it to be true. It's the belief that is killing us, and it killed me in my early years. I was very embarrassed at some of the things I promoted, and like I said, this is me going, hey, I was a fool, don't be a fool like me, right? It's okay to be a fool, because we grow up in the land of fools, in a dumbed down place. You should expect to be dumb when it comes to things like this. The only remedy to that is to learn the proper way, and that's what we're trying to show you, not through internet gurus.
Well, speaking of that, I do want to talk about how trusts actually work, because I know in a lot of our episodes, Clint and I have talked about the problem areas with these gurus, but what I do want to share is more about trusts and how they actually work, just so you have that knowledge. And a lot of the stuff isn't like some secret knowledge like these guys tried to pass it off as, right? So, but before I get into that, I do want to get into how KL supposedly uses trust and instructs his students and what type of trust he works with. So I'm going to quick what he talks about on that front. Okay, so should be able to see that. Yeah, so I have the definition of a statutory trust pulled up, because often a lot of these trust gurus are going to say that my trust is a non-statutory trust. It's under common law. It's an express common law trust is often what they will describe it as. And by default, any trust is an express trust. As long as it's written, it is a written trust by the settlor.
But let's be clear here. This is not a common law issue.
No, and common law is actually adopted by the states, and this is pulled up by the state codes on trust. I just pulled up Delaware's, and they describe the statutory trust actually as a business trust, because KL describes his trust not only as non-statutory, but he also describes it as a business trust. Okay. And trust me, I've worked with a few of his students, and each one that I've talked to that got his magic trust is always a business trust. where he claims it is not under subject of statutes, codes, or any of that. But
By necessity, a business trust would be a person in law and therefore has to be statutorily governed, administrated.
exactly, because that's another thing this movement completely misses. Now, they're very avoidant of persons. They think, that means a bad thing all the time. Now, there is some truth in that. However, when we're talking about trusts or companies, those are also persons. Uh, so
What you're saying is Rome is evil. That does not mean that when you're stuck in Rome, you constantly walk around and don't do as the Romans do.
right. So trust, because the gurus use the term trust law a lot, right? But trust law, it's not what you may think it is from that term, but basically,
Is that to suggest that trust law is not U.S. code?
right, right.
Is that what they're
It's its
saying?
own category of law, like it's separate.
It's like
highest.
equity.
It's the highest form of law, they say. But the thing is, with trusts, they're actually a state matter. Okay, so it actually trust law falls into state law.
Keeping
Okay,
in mind, though, that states are under federal. I mean, doesn't mean
well,
states go against the federal law.
we'll get into that. But yeah,
Yeah, I mean,
this is besides all the federal stuff and taxes.
right.
I'm just talking about the state level here. So the personhood of trusts come into play more so than the gurus want to admit. When you put a house or a car in a trust, let's say, the title changes over from you, the individual, the straw man, over to the trust name if you do it properly, if you put things in a trust properly, which none of these gurus are going to show you how to do that, right? So even if you do get this paperwork, they're not going to show you how to put things in it. Now, the person, the trust, that separate person owns it. Notice that.
If I somehow were to have a non-statutory trust, what claim then could I make on the trust since everything in the trust deals with statutory law? I would
Yeah.
not be able to even administer the trust in any way that has to do with the system of law in place or the system of law that controls the home, the car, the person that I'm suing. It doesn't really make sense that you'd want something outside of the law that you're using to protect.
Yeah, exactly. Well, and it doesn't make any sense for practicality's sake because in a trust, you're going to have the trustee, of course, right? That's one of the parties. Uh, the trust itself has a situs, basically a domicile you can think of. And that's going to be in the state, of course. It's not going to be at the federal government. So wherever the situs is also where the trustee is. The trustee, especially in an irrevocable trust, it's really important that both stay the same. Okay. Otherwise, it's not going to be properly administered and it's not going to have the protection. So now let's get into the statutory trust a little bit more. The statutory definition is generally incorporates the common law concept and the modern requirements of a written instrument and the filing of a document with the Secretary of State. Now, this is what the followers of the movement often think that anyone else outside the guru.
Therefore,
Yeah.
it's under common law because it says it takes from common law. Well,
Right.
we took from the law of England to make the United States law. Does that mean we're still under English law?
Well, what I was getting at was they. So they say that any trust you give a lawyer, anyone that's not a guru that I follow, that's a statutory trust, and they a lot of times they assume. I have had calls with these kind of people telling me, oh, well, basically they assume that you filed this statutory trust with the Secretary of State, just like a company, right? And it's actually not true. For an estate planning trust. Now, if you're filing an actual business trust, that is possible in states that have business trusts, like Delaware here. But it's for corporations' use, and we'll later get into the uses. It's not for estate planning, privacy, or asset protection that people are often thinking about when it comes to trusts.
Well, let me interrupt you there because is that what people are thinking? What are these gurus
No,
selling a
they're not.
trust? if you get a trust, you're going to be free and you're going to be sovereign and you're going to do it. Hasn't. I mean,
Yeah.
that's not what a trust is, guys. That's ridiculous. What Brandon's saying here is that he's actually showing you what can be done with a trust, whereas what these people are trying to sell you is that you're going to have a change of status and that you're going to have this and the other. None of that even applies to the purpose why anyone would have a trust, right? So what you're talking about now is the nitty-gritty, almost boring, right, truth about what a trust is. And I can see why people be like, well, no, that's not why I want a trust. And when they come to you to get a trust, they're like, well, what about my freedom?
Right.
What about what he said? And then like, well, no, I'm going to go with the guru.
Yeah, exactly. Now, why are trusts statutory on the state level? It's because, think of it like this. If I set up a trust for my family, let's say, and I pass, let's say for some reason, my heirs, maybe they're left with a mess. Maybe I followed one of these gurus, right? And I didn't properly fund my trust. So none of my stuff is in the trust. I die. So now my heirs are wondering, okay, well, what can I do? Well, the answer is you can't. After you die, probate is going to take place on the assets you didn't put or property items you didn't place in the trust. So there's nothing you can do at that point. It's the point of no return. Trusts are statutory on the state level because if there's an equitable dispute in the trust, maybe beneficiaries disagree and sue each other, then the courts get involved, obviously. So you can have stuff like that happen, or maybe there's a discrepancy in the estate plan itself, and there needs to be an actual equitable relief here. That's the main reason why these things are statutory, right? But also because of the asset protection. If I'm sued and my trust is not statutory, like the gurus say they would, you'd actually have no asset protection in the lawsuit. So creditors would be able to take whatever they want. Now, a lot of times the followers of these gurus are convinced that trusts are mainly for not only the status change, but also to get out of taxes. Now, there are several cases here on people using trust for these purposes, right? The tax shelter, essentially. But if you look into these cases, you can see that the business trust, the one that KL recommends his students use, are actually taxed as corporations because of their similarities.
You mean persons?
Exactly. You may think that this business tax is not subject to IRS code, and that's what KL literally will say. And we did highlight in our past KL show that, in fact, the IRS does not recognize business trust. Now, KL thought that was a good thing. But here, they're telling you, no. A business trust doesn't have its own taxation. It's taxed the same as a corporation. And you guys can look into this if you want. I won't read into each individual case. We won't, do that on this show. But I encourage you guys to look into each of these cases, all right?
It would be a good exercise to pull up a bunch of failed trusts and see what the results were and how people lost everything or had to go to probate.
It's funny that you mentioned that, Clint, because we literally have the authors of The Art of Passing the Buck. They have that as an example.
Why would someone that's an author of Passing the Buck, literally passing debt onto others, why would they even care about their family?
Yeah.
I mean, it doesn't even make sense.
Right. Yeah, and you later come to find out in this case, we'll go through the highlights, but this case basically shows, and the government says, these guys, because these two are the authors of that book, Art of Passing the Buck, the government basically says this was all for self-benefit, these trusts, and were not for your typical purposes of a trust, right? It was all for self-benefit, they say.
But you can be the beneficiary of your own benefit.
Well, it actually is legally okay to be the beneficiary of a trust,
come on.
but
this is an advanced concept, not for us.
Right.
We're only in this because we want to protect our assets and keep our estate, which was the whole thing that KL said, the name and estate. Well, that's what you're worried about, then do it right.
So, again, this is the government talking about the authors of this book here. The parties understand and agree that the entry of this order, this injunction, basically, precludes that the IRS from assessing penalties against the defendants for violations of the IRS code, nor precludes the defendants from contesting any such penalties. Parties further understand and agree that the court has jurisdiction over this matter for the purposes of implementing and enforcing this order. Now, this is important that I'm reading this because a lot of people say the art of passing the buck actually beat this case. And that's what they'll say on their own website. This website right here, they'll say, welcome, hey, we basically fought the system and we won with our tactics here.
And they were ordered not to even do business anymore, not even to sell that book, right?
Mm-hmm. Yeah, so they link on the website like, hey, you can read the case yourself. Now, what they didn't share is they, under this injunction, they had to share this link to show people we lost, but they're going to lie on their website and say we won, right? But if you actually read the case, yeah, they're organizing, selling tax shelters plans to these people, just like Kale's audience, right? And Kale, by the way, he lists this book as one of the books required you read before you actually work with him, right?
So once you understand then that these are tools and things that government provides that we can use, right? We can utilize them for our benefit. Well, then it does not make sense that you're standing adversarially against that which is providing you the tool, right? It doesn't make sense that you're going to say, okay, well, we're going to use this tool against you and try to avoid taxes. Ha 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 ha. Well, no. I mean, you don't borrow someone's thing and then use it against them. It doesn't make sense.
Yeah. So
I find myself at saying it doesn't make sense a lot today.
So yeah, the whole concept that trusts get you out of taxes simply is not true. The main selling point of trust is not that, but that's what the gurus are gonna pitch, right?
Well, it might get you personally out of taxes, but those taxes got to go somewhere, so they go to the trust.
Well, that's funny. We'll talk about that. There's some complications there.
Well, yeah, I'm not saying it's not you're not liable. I'm just saying you're making the trust liable, and if the trust doesn't pay, then what?
Well, that's the thing. Then, because most of these trusts that the guru set up are considered by the IRS grantor trusts, where the grantor still controls the trust, right? Even if you technically aren't the trustee, a lot of these arrangements make it so that you do. So the courts, just like are passing the buck, will throw it out as a sham trust arrangement. So in fact, you do still control the trust.
Right.
And so anyways, the IRS will usually consider your trust to be that. And then under the grantor rules, which they have, then you'll be taxed at the individual rate. So it'll basically be a pass-through, the trust itself. So it'll be disregarded for tax purposes. Now, another thing is, KL says, my trusts are private. Now, what is a private trust? Because he never actually talks about that. I mean, they make you believe that, well, a private trust has to be from one of these guys, right? They're designed to benefit private individuals, such as one's family or close friends. This is your typical trust arrangement for everyday people, right? So you're not going to take this private trust document, file it with Secretary of State, like a LLC or a DBA, like KL's recommending. So anyways, just wanted to throw that out there, that trusts by default are private.
Well,
you don't have to go through a guru to get one.
No, privacy is the way you act. It's not, you don't label something as private or public.
Right.
It's like the whole point of having the trust, because I think the word private is still confusing to people.
Yeah.
The whole point of having the trust is so that you can administer your affairs privately without having to go to probate.
Exactly.
In other words, you're doing what would be done in court before someone dies, essentially. You've already handled what probate would do publicly. You've handled it privately within the trust. that does not make it a private or public trust. It just makes it a trust. And the way that that trust allows you to act outside of the public court, namely what I just said, damn it, that court, is what is what makes it the action that you're taking is private. But even that is mislabeling, because anything you're doing is going to be has to be on the record, or it's not. I mean, what's the point of doing it? What's the point of having property if you can't show it's your property publicly? Right? I mean, even if you're keeping that private at the time that you need to, none of it. These two words should not be polar opposites. They actually work together, and that's, I think, the hardest part for people to understand.
Yeah, exactly. Okay, so what is a public trust? Well, this is going to be your typical charitable trust, because a public trust is designed to benefit a religious or charitable purpose or specific part of society. Okay, the beneficiaries of public trust are registered societies or entities. Because their goal is to benefit the public as a whole, common examples include welfare, schools, roads, and military trusts. Okay, so this is not at all what the gurus are telling you what public trusts are, okay? Because remember, they say public trusts are any trust you get from a lawyer, anyone else from us.
You know, charity is religious or charitable. Those are the two words there that have to be put forward, because especially in this case, the beneficiary cannot be, you're trying to benefit someone other than yourself, whereas KL and all these guys are strictly selling, hey, this is all for you. This is all just greed.
Right. Yeah, exactly. Now, what are charitable trust purposes? Wait.
Let me ask one question before you go on.
Yeah.
Would I be correct then in saying that if you call it a public trust, just as the title would suggest, that the beneficiary, the title suggests who the beneficiary is. So in that case, the public is or a public entity is the beneficiary, whereas a private trust, it would be a private individual or private family.
Yep.
So it's really the beneficiary that is either public or private.
Yeah. But also the design of the trust and the trust language.
But even a private beneficiary is a public person.
It can be. Sometimes private beneficiaries can be a company.
Or a person. A person.
Yeah, it could be
company,
another person.
An association, whatever. It's always a person. It's never somebody not in the system, is what I'm trying to say.
Well, yeah.
And that's kind of what they're trying to sell you, is that you can do this outside the system. No.
Exactly.
If you're in the Matrix, you have to have a character. If you're playing Monopoly, you have to have a freaking character.
Yeah. Right. So yeah, I just wanted to establish that, because I know these are like the root beliefs of this movement about trust. Right. And like I said, everything KL says about trust, the opposite is true. I am a beneficiary of a trust. That's what's going on here today. So this is an excerpt of KL's response video about me. And this is basically him listing out a scenario where he's in court, okay? And he's using this implied trust to his benefit, where he's claiming his rights as beneficiary, right? If I'm beneficiary and that guy over there is the trustee, that guy over there meaning the judge. So he's saying, remember, this is assuming the implied trust, the constructive trust, has a trustee, which it does not. I have an equitable interest in this case, and thus I need to see this in front of an equity judge. Remember, there is no such thing as a separate judge.
Sorry, buddy.
You can dictate the court proceedings and what kind of judge you're going to get and what kind of rules you're going to get and play by, and it won't be the regular rules.
Shall we go over his case again to say, not so fast, buddy?
Because again, trusts are a special thing that they see And that's where your remedy is in court, and is getting them to see the trust.
Getting them to see the trust?
Yeah.
Well, wait a minute. If there was a trust, you'd have a document that shows there's a trust. That's all they'd have to see, right? Now, I think the most important lesson we can take is that if you follow these gurus, you're going to end up looking like this.
Exactly.
You're going to look just like him. You're going to be a sad old man, overweight, and,
Making response videos, calling guys like me 15-year-olds, and
yeah. This is what's going to happen to you.
Okay. Well, we talked about this earlier, so we won't go through it. But yeah, there's two types of implied trust: resulting trust, and then the constructive. But the constructive is what Kale was trying to describe, just didn't know how to. But yeah, again, does not apply to what he thinks it means. And to be honest, Clint, I for a while thought Kale didn't believe this stuff at all, like anything he was saying. But now I'm starting to think he actually believes a delusion he tells himself.
Actually, you have the benefit of learning this is fraud early in life, okay? And for me, when I started looking into this, the internet was still new, all this stuff, we didn't. So it was even easier to believe that this stuff was true because you couldn't just go on and disprove it like we can, or at least it was very difficult to. And we did do research. I remember going to the law libraries and reading stuff. It was weird. But see, that transitioned me into the internet. I would just continue to read law library stuff. I wouldn't look at, and the second that I started looking at gurus was the second I got off course, right? So, yeah, I mean, like I said, you have the benefit of not being put into this religion, this mythology that's been around, like I said, for 50, 60 years. And that's a good thing, right? Except that it makes you a pariah, like me. It makes you hated because you'll always be hated for telling the truth and exposing the fraud because people want to believe it. And I truly wanted to believe it was true, so much so that I would argue with people even though I had no idea what I was talking about. And that's a lesson to be learned. It's actually an important spiritual step forward when you come to this understanding that you're wrong about things, that you have a belief that's not true, and that you're actually willing to harm people and their reputation to prove your point, and your point is wrong. That's a big step in life.
Yeah.
Provably wrong, I should say.
Yeah, exactly. So, KL with his non-statutory common law business trust, I found this interesting thing that Deller was talking about that. They say several jurisdictions impose a control test to determine shareholder liability. Personal liability is imposed and the trust is disregarded when shareholders exercise too much control in the management of the trust. Where beneficial owners retain control over the trustees, the common law business trust fails and shareholders will not be entitled to limited liability. There was also a risk that other jurisdictions would not recognize a common law business trust as a separate entity or enforce its terms, including the limited liability of shareholders. Common law business trusts were also not always successful at obtaining the desired business tax advantages. See Morrissey versus Commissioner, which I showed you guys earlier, which listed other cases. Common law business trusts which possess corporate attributes were held taxable associations rather than property held in trust. Okay, so I wanted to share this because the control test up here is the important part about this. And this is not only applicable to non-statutory common law business trusts. The control test applies to any type of irrevocable trust. So even if you think you have asset protection because you got an irrevocable trust from one of these gurus, but you can't pass this control test, which Art of Passing the Buck showed that them and their clients could not pass this test with their way that they arranged their trusts. And with the clients I worked with who've gotten these types, certainly cannot pass this control test. And oftentimes they are the trustee directly.
But you got to look also at the names of these cases. the
Yeah.
inhabitants of Milton, right? This would be, yeah, okay, I could see why that would be a common law kind of, it's a state thing, so it's not federal, and we're trying to stay out of the yeah, I can see that. Frost versus Thompson. These are not like Chartier, right?
Yeah.
These Lumpia royalty, right?
Yeah.
These aren't like family trusts.
Exactly.
First of all, they're like a township, or right, and you're doing business as a town, but you're trying to do it privately, so you form a common. It makes sense that you'd want to do this, but this would be an extremely limited flavor of trust that no one I can think of us would ever use this unless we're forming a city, maybe. But even then,
Yeah.
I don't even think I would go this route.
No. You just go down the corporation route.
Because remember, a city's a person. It's a corporation too.
Yeah. Now, just a reminder, KL is one of these gurus that encourages that you file Form 56 to the IRS along with his other paperwork. Now, I just wanted to share this response from the IRS that someone shared that they got after they submitted the Form 56. Basically, the gurus are saying, hey, you do this, and the IRS is going to leave you alone for taxes. And if they don't respond, then you know for sure it worked. But they don't have to respond, and it works. Well, the IRS actually started to respond. They started off by saying, Dear taxpayer, thank you for your correspondence, which we received on October 2021. We reviewed the information you provided and determined no action is necessary on your account. And the gurus will say that's a good thing, right? We received the revocation of election, Form 56 letter, established by the U.S. Congress signed October 2021. If you have questions, you can call. If you prefer, you can write. Okay. So it's basically saying, look, this did nothing to change your tax liabilities. But the gurus, even if you were to present them with this evidence, they're just going to say, well, yeah, this is a good thing, right? This is no changes to your account, so that means you don't have to do anything.
Remind me, what's the purpose of a revocation of election?
Oh, it's basically that, hey, I'm not a taxpayer, with a one-page letter, mind you.
Okay, but do they not understand that, okay, it's great that you're not a taxpayer, but the second you do anything in the name that is taxable, then the name that you're surety for, right, that you're agent for, owes the tax. The taxpayer is the person, not you. Great, you're not a taxpayer, but your person is. Right. And you don't get to change the status of the person. It's their person, not yours. So the second that you operate that person in commerce, that status, the name, the number, all of that stuff, that is when tax is going to be assigned to the person. And if you don't pay it, they're going to come after you because you're not administrating the taxpayer as you should, which is the person. It's not hard to understand.
Yeah, exactly. So we already went through that, congressional record that supposedly proved what KL is saying about the public trust. Turns out it didn't exist at all. Now, another thing that KL encourages is that you get his trust.
Before you say that, I'm happy. We're happy to see Exhibit 4. We're not saying it doesn't exist, but apparently we can't find it. You can't just put when you put a source like he put, it's a very general source. Congressional Record 1967. That's like a massive tome of information. That's a great way of saying something without saying it, right?
Yeah. Yeah, exactly.
So, if you have the evidence, why don't you be a little more specific? We'll be glad to take a look at it.
See, I first thought this was the record he was talking about, but it turned out this exhibit doesn't exist.
Yeah, that's probably just something he needs to correct on there and show the actual link or whatever. But I've seen these before, and
yeah. So just a quick review of his process. Not only is the business trust involved, but he also encourages you get a DBA to use. But we've talked about how, hey, the DBA, it's not a separate legal person away from you as the individual. In fact, it is you as the individual. So I just wanted to give you that
I
because
thought DBA was an assumed. So I didn't even know you had to register it.
now the DBA, if you use that as a business for a business, the business itself is going to be a sole proprietorship. So it's not going to be a business entity. So it's not going to be a distinction between the business and you, the individual, the straw man. So you're going to have unlimited liability using this DBA sole proprietorship model that KL is encouraging that you use. You're going to have unlimited liability for losses, debt, and there is no separate income tax to be paid for the proprietorship. All losses and profits are reported on the individual's tax returns.
So they're saying, oh, it's horrible the way Brandon wants to limit your liability.
Yeah.
No, you should take full liability for everything. Really?
Right. Exactly. Because remember that supposedly KL is saying that the DBA allows you to do commerce in this world without incurring any liability.
What?
Yeah, when he, in fact, is incurring all the liability as the individual. And he goes on about how the natural person doesn't pay taxes, kind of like Alphonse, very similar. They cite the same case. It was the Pollock versus Farmers loan trust company. So this is basically a case where they talk about the guru would say they talk about the natural person, how the natural person doesn't pay taxes. Kale literally said this on his response video and says, I'm the stupid one for not knowing about this, right? Well, you read the case, and it has nothing to do with what he's talking about. Okay? It does talk about taxes, but doesn't talk about getting out of taxes with what he's describing.
Sometimes I wonder if they're just not writing things so that they can quote. They can quote themselves, but not quote the case that shows what they're saying is frivolous. To make you think that they won the case or that they made a point, right?
I would be surprised. I mean, sure there might be.
They're literally putting their own words in just so they can quote them.
Yeah.
Out of context.
That's strange when you think about it that way. Yeah. Yeah, so I was talking about the control test earlier, how most guru trusts wouldn't be able to pass it. Now, in a revocable, now sometimes people say it as revocable. Revocable trust, you're going to be the trustee and the settlor, and you can be the beneficiary. That way you get use out of the stuff in the trust while you're still alive. And then when you pass, the remaining beneficiaries get use, right? So in this arrangement, you're the trustee. The trustee is like the manager of the trust, right? If you don't know. Now, in an irrevocable trust, you cannot be the trustee, actually, in order to get asset protection, lawsuit protection, even privacy. Because the trust, if it truly owns your assets and property items, your name's not going to be listed on the deed. So say like your house or your car. So the trust would actually be listed there. And in some property items, the trustee's name is listed on that title. So if you are the trustee and you think you're getting privacy, you're not.
Well, so
you're not getting privacy.
The last thing you'd want to do is send a letter to the IRS. Like you're putting yourself on the radar. That's the opposite of being private.
Right. But anyways, yeah. So the control test is really important here because most of the guru's victims are not going to be able to pass it. And then now I'm assuming that most people know the differences between revocable and irrevocable. Whereas revocable, you can change it while you're alive, the trust. Now, because of that flexibility, because it can be changed while you're alive, it does not have asset protection. So if I'm ever sued, if a creditor goes after me, let's say, and they see that I put all my money and my assets in this revocable living trust, they're going to lick their chops. They're going to get excited because they know that I am still in control. And it can, even if I'm not the trustee, it can still be changed so that they can go to the judge and say, hey, judge, I want this trust changed so that I'm the beneficiary, no longer this guy or his family. Because we're suing him because of XYZ, right?
As another reason to be very wary of power of attorneys and stuff like that.
Yes. So while revocable trusts are the most popular out there nowadays because of the flexibility, because most people like the way that sounds, and for that matter, most people, all they're thinking about when it comes to trust is estate planning, just probate, court avoidance. So yes,
Well,
it's revocable trust. are good for that, but not asset protection.
Because people are living in like a social media soap opera. They probably change their beneficiary 20 times before they die.
Yeah.
So they'll hate everybody.
Right. Yeah, I'm sure. Now, the irrevocable trust is where you have the third party as the trustee to get that asset protection. Now, some people hear that and they get terrified by the idea of an irrevocable trust. They think, oh, well, now I lose all control of my property and assets. Now, I can't do anything with it, which actually isn't. There is. Let me clear that up, okay?
Well, but wait a minute. How do you lose control if it's your property? The fact that you can lose control obviously means that the notion that it's private property, that's your property, again, no. This is a tool to handle a property, which is necessarily a status of something in the system. So again, it's not yours. You're using this tool to manage government property that you claim under your estate.
Yeah. Anyone but yourself and even your spouse, because that would be too close of a tie. That would be an arm's length tie is what they would call it. So that wouldn't even provide protection. So what I often recommend people do, if they don't like the sound of it, first of all, you got to change your belief. Like, I don't want my house to be in my name or have myself tied to it really directly, publicly.
That was one of the hardest parts for me, actually. Because now you're talking about real privacy, and that's like, oh, what do you mean it's not in my name? But you're at the same time, you're like, I don't want to be public. I don't want the name. I don't want.
Yeah.
And then you suddenly actually do it. You're like, oh my God, I feel so naked.
Yeah, exactly. So yeah, let's say I did put my house in my trust. Now, what you can do is layer these persons. So you do have some flexibility where you can be the manager of the holding company that's owned by the irrevocable trust, not you.
Something that might help people, because sometimes metaphorical stuff, sometimes help. If you look at these shapes and you look at the way they work and how they rearrange or redirect, it kind of reminds me of an electrical chart, or even in sound engineering, where you got a bus basically, and that bus, purpose of a bus is to take it to another place. So you put a bus in, and this is very much like an electrical schematic where you're rerouting the power. It's kind of a good analogy, because it's your power that you're putting here. You're not losing the power. You're just displacing it into a place where you're getting a beneficial protection and insurance, basically, that our trans they them Uncle Bob is going to receive, the proper beneficiary. So it's kind of like a schematic or the real thing, where you're capacitors and things that hold power and then release them and redirect them. And I don't know, that might help somebody understand this, because you're not actually losing it. Even though it's no longer in your name, you're not actually losing control.
Exactly. Remember the phrase, own nothing but control everything, while still passing the control test. So that is the name of the game, essentially.
And everybody should look up control test.
They really should.
Very, very important. If your trust doesn't pass the control test, it's worthless.
Exactly. Now, someone's estate plan, let's say, doesn't have to be this complex. You can get away with just a simple, plain and vanilla revocable living trust, which is most people have when they get a trust. It's low cost, it's low maintenance, and it sounds nice to people typically. Just know there are limits to it. So I'm not saying you have to have even the holding company or this diagram here on this next slide. If you have multiple assets or property items, you really want to take this stuff seriously, because let's say I have rental properties, for example. I don't want my trust's name on that title. Okay. The trust that owns everything else. If my tenant in my rental property sues me and my trust owns that property, the point is of the trust is to stay private from all of that to begin with. So why would you have the same trust that owns all of your other assets, your rental property that's dealing with the public, right? So these are things that you have to think about. If you have businesses, if you have assets, it's not as simple as just putting everything in trust and thinking you have maximum privacy, asset protection, and tax liability planning. But really, those are the areas that we're trying to accomplish maximum efficiency with. And this is kind of what it can look like depending on your portfolio. But
Hey, Brandon.
yeah.
I actually have to duck out. I apologize.
Oh, okay. Yeah.
Keep listening, folks, because I mean, what you'll notice about what I notice about Brandon is he sounds like a freaking. He sounds like if I went to an estate planning office somewhere, a legitimate one. He sounds like like he's selling a legitimate actual. I mean, you sound like what I'd expect from someone trying to put forward a plan, right? A structure, right? Whereas when I'm listening to these other guys, the gurus, right? It's full of intrigue and mystery and trying to separate yourself and trying to be private and trying to do all this stuff and you're like, and then when you come along and you're reasonable and thoughtful and you're expressing how the law actually works, I can see why people are adverse to it. I mean, they're actually adverse to the right way because the wrong way has been romanticized and conspiracized and right, and all the mythology and all the false history and all the false narratives. It is starting to make sense why people are thinking we're the bad guys.
Yeah.
Right. So anyway, I just wanted to say that, but I do have to go, man. I apologize. Good talking to you about this. I'm glad that we have some closure on Mr. Beneficiary. Oh, what a joke this has all become at this point. And these guys are still supporting it. All these hosts,
They are.
they're still supporting one another. It's like at some point it's got to fall apart,
And I think we're starting to see that.
Maybe.
The podcast hosts haven't acknowledged these things yet, but at some point they might have to. So
you would think that all of these guys, the Rice and what's the big one that I always,
Crow 777.
Crow, you'd think that at some point they're going to have to come out and say, okay, look, I mean, the evidence is 100% against us. There's no proof. There's no success stories, nothing. We've literally taken your money. We've enriched ourselves. We've used something that's supposed to be for your good against you. That has to come out at some point. And you know what? If it doesn't and this continues, I got to be honest with you, I'm done. If you're not going to listen to us and you're not going to share this and you're not going to insist that the members of your group, because you have some social media attachment or fear of rejection, I'm sorry, but then I guess at this point you just got to say people deserve what they're going to get, right? I mean, if you're still falling for this, I just don't know what else to do about it, really. Because we're not being given the platform. They're certainly not going to have us on their shows, right? So not in any less than adversarial way. So yeah, it's a pointless endeavor at this point. People are either going to listen, they're going to look at the evidence, look at the case, or they're not. And I'm pretty much going to be done with this unless I can recover my whole series I did on trust, which will really help people expand their knowledge on them. I'm done. I don't want to do this anymore. I'm tired of exposing fraud and being the bad guy. I don't why am I doing this, right? It's only hurting me. It's kind of like what Elon Musk says, man. He's the whole Doge thing is just hurting him. You don't want to do it anymore. Why try to help people if you're just going to get slammed for it? And you know what? Same organizational thing, right? It's an organized group of sham artists, scammers that are supporting one another. So, we've done our duty.
Yeah,
So,
I think, I mean, between all of our work on these subjects, there really isn't anything left to talk about, especially the trust gurus now. So hopefully this helps you guys at home watching this understand a little bit more about KL and the people that circulate these legal fictions, right?
fiction about the fiction.
Yeah, so ironic, isn't it?
Yeah.
Yeah. So, well, thanks for joining, Clint.
Well, I mean, you can continue. I just had
Yeah.
I'm sorry.
I'll continue a little bit. We'll wrap it
Yeah.
up.
You guys take care, be well, and maybe we should start a business on how to get people out of the traps they've fallen into.
That could be a whole thing, couldn't it?
I mean, at this point, and I don't even want to say that because then that's what they'll do, and
That's usually
they'll
what they
take
do,
that
yeah.
over.
Yeah.
Anyway, all right, man, take it
All
easy,
right,
dude.
later.
Thanks for this. It was good. Do. I use my real name, if you want to call it that, my actual name, because look, I don't go to court. Anything I handle in the mail. That's my court. So there's a reason that I'm successful at things where other people might not be, and these things don't go on the record. So, I avoid these spaces,